Hello everyone, welcome back again to my channel. Before watching this video, don't forget to like, comment, and subscribe. Now let's start this video. Implementation of Agreements with Foreigners Part 3. Arrangement with Japan. The Japanese undertook not to operate in areas other than specified in the arrangement. Article 1 of the arrangement grants certain Japanese vessels permission to call at the port of Ambon, where they would be provided facilities for tuna fishing in the area. Before being able to fish in the Banda Sea area, however, the fishing vessels were to be issued certificates from the Indonesia Embassy in Tokyo. The call at the Indonesian port was to be made at the end of each fishing activity for purposes of certification by the local naval authority. Application for permission and facilities had to be secured by the association on behalf of their members, specifying therein the names of the vessels, the name of the owners, and the vessel's registrations number as well as its tonnage. Additional requirements such as a crew list and a photographs of vessels were also imposed. Japanese fishing vessels grants permissions and certificates were also required to be specific markings on both sides of the vessel's brides, the details of which were specified in the arrangement. To be able to finish in the specific area, fishing vessel had to pay a certain fee depending on the class of the vessels used. For a class of vessels, namely a vessels of 40 T class of less than 7 GT, the fee was fixed at $300 per vessels per year, while for a Class B vessels, namely a vessels of 103 class of not less than 70 GT but not larger than 500 GT, the fee was fixed at $390 per vessels per year, payable in the yen through the Indonesian Embassy in Tokyo. To protect local Indonesian fishermen, Japanese fishing vessels were not allowed to operate within the limit of 30 miles from the island of Ambon and from other areas to be mutually agreed upon. Likewise, Japanese fishing vessels were not allowed the use of motherships or transporting vessels. Each vessel was to be on its own and fishing was limited to the long line method. The number of vessels allowed to operate under this arrangement was limited to a maximum of 250, not more than one-third, of which should consist of 103 class, which should consist of 103 class vessels of not less than 70 GT but not larger than 300 T. Within this category, however, vessels of approximately 200 GT but not exceeding 300 T were allowed. The rest would be vessels of 40 T class not larger than 70 GT. The maximum catch of the whole Japanese operation under this arrangement was limited or not more than 50,000 T per year. The arrangement took effect on its signing on 9 July 1968 and was to be in the force for only 1 year. The form and the contents of this arrangement were peculiar. First, it was negotiated between the representatives of the Indonesian and the Japanese governments, but it was signed between the government of Indonesia and the National Federation of Fisheries Cooperatives of Japan and the Federation of Japan's Tuna Fishermen Cooperative Association, both private organizations. It seemed that while the Japanese government was eager to protect the interests of its fishermen, it was nevertheless reluctant to conclude an official agreement with the government of Indonesia. Perhaps Japan feared that such a bilateral agreement might be interpreted from the legal point of view as its indirect but de facto or de jure recognition of the Indonesian archipelagic concept. Secondly, the arrangement regulated Japan's fishing activities in the waters between Indonesian islands. From the very start, the Indonesian government disagreed on this formulation and preferred the phrase to simply read in the Indonesian waters. The implication was clear. The Indonesian government wanted clear, legal Japanese recognition of its archipelagic concept, while the Japanese side insists on maintaining some semblance of legal non-recognition through the formulation. Thirdly, the Japanese side was willing to pay for access to the tuna fisheries in the Banda Sea. Although Indonesia considered the amount paid as very little or meaningless, it nevertheless viewed the payment as an act which constituted Japan's recognition of its archipelagic concept. The Japanese side, of course, simply viewed the payment as a fee to enter an Indonesian port since the Japanese fishing vessels operating in the Indonesian archipelagic waters had to report the result of their operation to the predetermined Indonesian port. Fourthly, the agreement was valid only for a limited time, 1 year. Thus, it had to be renewed. Every time, and each time the discussions would center on the need for such an arrangement and on the points previously mentioned. Basically, Indonesia did not consider the arrangement beneficial to her and therefore wants to be modify the terms to better suit her needs. Yet, the Japanese side considered the arrangement extremely important primarily because it involved activities and the economic life of a certain sector of Japanese electorates. Thus, it was politically significant for any Japanese government in power. Each time the negotiation bogged down, political pressure would be applied on Indonesia. As a result, the arrangement was renewed 5 times and replaced by a new arrangement in 1975. Between 1968 and 1975, the arrangement generated less than 10 million US dollar for the Indonesian government, namely 147.640 in license fees and 7,800,000. By 1975, the Indonesian government had become very reluctant to continue the arrangement. However, it had to continue giving special consideration to this peculiar Japanese interest because the Japanese government considered the solution of the issues essential for their position on the matter of archipelagic states in the Law of the Sea Conference. Before Prime Minister Tanaka could agree to express sympathetic views vis-a-vis the archipelagic principles, when he visited Indonesia in 1974, the Indonesian approval to continue the arrangement in the archipelagic waters had to be secured first. By 26 September 1975, the validity of the interim arrangement had expired. Again, new negotiations were made, but sides decided against a sixth renewal of the interim arrangement. Instead, a new arrangement was made, this time between an Indonesian state fishing enterprise, the Perikanan Samudra Besar or PSB, and the same Japanese Fishing Association mentioned earlier. The new arrangement embodied provisions for tuna fishing cooperation on the basis of a profit-sharing arrangement. The new arrangement also required the association to prepare and transmit to the PSB a sailing plan for tuna fishing for each contract year. The plan is to be carried out after due acknowledgement from the PSB, which will be given expeditiously. Article 2 of the contract. The area of operation under the new arrangement remained the same. Example, the waters between the Indonesian archipelagic island as provided for in the interim arrangement. The interim arrangement, Japanese fishing vessels were not allowed to operate within the limits of 30 miles from the island of Ambon. But unlike the interim arrangement, the Japanese vessels were not allowed to operate within 15 miles from the other specified group of islands, such as the Geser, Gorong, and Banda Neira group. Okay everyone, thank you so much for watching this video. See you until the next time. Bye bye.